Somebody told me today there's not many cases where the attorneys for a potential child murderer are hated more than the child murderer themselves. But today I'm here with defense attorney Anne Benaroya, and we are talking about the Frank's motion and the attorneys in the Delphi case. Before we get into the specifics of the motion that was filed today, let's just start with the overall premises and then work our way down to the specifics in the case.
Okay.
Okay, so let me start reading where everything kind of starts with, and first of all, and that is the Fourth Amendment to the U.S. Constitution. So, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that is the
You
backdrop.
left out the neutral detached magistrate or judge, which is the key to the Franks hearing. What
Okay.
makes it the judiciary, that branch of government involvement is very, very important. That's why Franks is different from ordinary suppression hearing.
Okay. So just getting to that, because normally let's describe the normal process for a search warrant. The police and maybe working with the prosecution or the police themselves have probable cause in their minds that they think that if they do a search or ask for a warrant, they'll be able to find specific information of a crime being committed or something that will help them solve a crime, right? So what they have to do is they have to fill out an affidavit or sign an affidavit and give it to a judge, and then a judge signs off on a search warrant. Is my understanding correct?
Okay, pretty much, yeah. The police will file what's called an application for a search and seizure warrant. The application states the nature, the crime, or the alleged crime. Now, the very, very important part about affidavit, under oath, an affidavit is made under oath. Probable cause under oath. Probable cause is factual. In other words, the affidavit must allege specific facts, again, and particularly describe what is to be seized, what is where to search, what to seize, and who, if it's, and whose premises. Now, the process typically, again, the police develop probable cause, the facts, but it's a very low standard. And here's where we get into trouble because, again, we're accustomed to the reasonable doubt standard in criminal proceedings because at trial, that is the standard, whereas the standard for merely charging or for search and seizure is probable cause, which is simply a reasonable belief. I mean, again, it's not good faith because good faith can be self-serving. That's purely subjective. Although, again, but the reasonable objective belief that facts exist to support probable cause for murder and kidnapping in this case. Now, the issue is specifically with search and seizure warrant. What are the probable cause facts, or what are the facts that support the search? Where the place to be searched? Why Richard Allen's house versus your house or mine? And what exactly are the police looking for? Well, again, the more serious the crime, typically the more conclusory the allegations in the affidavit. Unfortunately, we don't have the application, or at least I've not seen the application for the search and seizure warrant that was executed on, I believe there may be more than one of them. But I've not seen the application or the affidavit supporting the again, murder is a pretty broad crime, but in this situation, we know that the mode of death was strangulation, not gunshot. So why are the police? The police would be looking for garrotes, any evidence of anything related to strangulation. They'd be looking for Mr. Allen's clothes because the witnesses described they described a man on a bridge nearby the area where the two young girls' bodies were found. So they'd be looking, the police would describe the clothes, the person the two witnesses described, The clothes that the man described by the two witnesses to the police who had seen a man that matched, where they claim matched Mr. Allen's description in the area where the bodies were found at, I believe it was two o'clock, approximately 2 o'clock on February 13th.
Yeah, that
So
is correct. The
the
one thing you are
clerk
missing.
would
Oh, sorry.
describe the clothes, would look for the clothes because those are going to have DNA. They might have DNA evidence, like, right? That would
Correct.
just
So the
they're
one thing that why they would be searching for a gun was that there was a bullet found between the two bodies. So I mean, I understand that the police were
they're
searching for a
definitely
gun.
gonna, yeah, then they're definitely gonna be looking for a firearm. And depending on the caliber, the type of bullet, your cartridge, they're gonna look for fire. Again, they're gonna say firearms generally, but they'll specifically be looking for anything that would use that cartridge.
Okay.
So yeah, they'll be looking for firearms. And again, why does it matter? Because firearm is not something that a firearm is not going to, it's not tiny. I mean, some of them are quite small, but where is a person going to keep a firearm? Like, are they going to keep a firearm in the oven? Probably not. So in other words, the nature of the property that the police are looking for defines to some extent the scope and the appropriate, like how far, where they can search it. What they can seize defines where they can search, and to some extent vice versa. Then again, but that goes more to the execution of the warrant rather than actually its actual application. The, what makes the Franks situation so significant is a warrant. The Fourth Amendment presumes that judicial permission. A warrant is basically a note. It's like a note from your mother excusing you from school. It's a note that gives the police judicial authorization to search and seize. This is whereas most of the searches and seizures that we hear about are exceptions to the warrant clause. So the warrant clause of the Fourth Amendment says a search pursuant to a warrant is presumptively constitutional and valid until Delaware versus Franks, which is a 1978 case, Supreme Court case. The uh, the law said that a search and seizure warrant was basically unimpeachable. The remedies for police, again, lying on the affidavit were perjury, collateral proceedings, perjury, that would be an adequate remedy. It's not, because who's going to prosecute the police for perjury? Tort claims after the fact, well, most likely it's going to be convicted. So good, there aren't going to be any tort claims. In other words, there are a lot of arguments in the Franks case for why there should not be, why the defense should not, the defendant should not be allowed to challenge a search warrant. And the Supreme Court said none of those remedies were adequate. Only the exclusionary rule under Matt versus Ohio that says the prosecution cannot use evidence that's illegally seized or seized in violation of Fourth Amendment rights in the prosecution. Well, again, because the Fourth Amendment says warrant search is presumptively valid, the burden is very, very high in Frank's hearing. Basically, what the defense has to prove is that the police affirmatively misled the court. In other words, again, it may not necessarily be perjury, but lying by omission. And that's what, as I understand, all of the Frank's hearing motions that I've read in the Allen case are alleging that the police have deliberately withheld exculpatory information, and that they specifically withheld exculpatory information that could have alibied Mr. Allen or put him elsewhere at the time the young women were killed, and could on the one hand or on the other could have extended the time for this crime. In other words, the alleged time when the crime occurred is between 2:15 and 4:30 on February 13th. But the cell phone evidence that's alleged in the most recent Frank's hearing motion could potentially, it enlarges the scope of time for the potential murder for quite a bit until the next morning of February
Yeah.
14th.
So let's go over what he is alleging in this news motion to understand it and how I understand it. So what I understand is that on February 13th, the girls were reported missing to the police officers sometime that afternoon. I'm not sure we know exactly time. I didn't quite look it up. So then what the police officers or one of the detectives called AT&T or whatever cell phone provider. I think it
Right,
was
the carrier.
18,
I think it was
the
AT&T.
carrier of the girls, and said, "Hey, we have a missing person girl. She's missing. Can you please try and locate the phone for us?" And so AT&T has a tool called a ping, which sometimes are what they can actively look for a cell phone. So they have the software that says, "Hey, this phone number where's the phone on this? Can you help me?" Or their software in their system says, "Can you try and find this phone for me?" And
Right,
what they said in the warrant or in this motion was that AT&T was set up so that every 15 minutes it would try and locate the phone. So if the phone was on the move, they could maybe track which towers it was following to see which road maybe they're following, or specifically, even if they could get a full triangulation, they'd be able to find the phone and then be able to find the missing person.
right,
But they could not do that here. What the question or the problem that came up that was stated in this motion was that around 5:44 p.m. was the last contact from the AT&T cell phone to the girls, one of the girls' cell phones.
right,
So then the sergeant or one of the police officers thought, well, the phone must, I mean, logically the phone must have just died from from the battery or
right.
battery, or it was placed somewhere that the cell tower can't read or it
But
can't
they
see the phone.
continued pinging for how long after?
And
I believe it was they started at 5 and then continued pinging for how long?
it was until the morning, and then what ended up
Right,
happening was at 4:40, somewhere 4:30, 4:45 in the morning, the phone started responding to the pings.
right,
So somehow over that 8 hours, the phone was not responding to pings, and then all of a sudden it started responding to pings. I guess the state's probably going to say, well, maybe there was some atmosphere that got in the way of the cell phone pinging, but one of the more logical explanations is that somebody turned off the phone around 5 or 6 o'clock that night to do something, and then came back in the morning and turned the phone back
right.
on.
Exactly.
Or it also could indicate that the bodies were moved during that time.
Exactly, because the phone was, as I understand it, the cell phone was found underneath the feet, I believe, of one of the victims. It was found at the burial site, but again, the burial has indicia of having been staged. So, and it's very unclear whether the murders took place where the bodies were found, because there is evidence of having staged that scene. So again, I think that what the most recent Frank's motion is alleging is that the police knew, and again, remember a Frank's motion, the key is that the police had the information and did not disclose it to the judge when they made their warrant application. So this motion is saying that the police knew that the cell phone, was not at this burial site, or could not, or may not have been at the burial site, very likely was not at the burial site as of, what was
6
it,
p.m.
after 6 p.m. on the 13th.
around there.
And then all of a sudden, and then it comes back online at the burial site at 4:30 in the morning the next day. So something happened during that period. Now, why would the police? The question when we're looking at a Frank's hearing is whether that piece of information, and again, let's just stick with that piece because there are several others that raise issues, but with that piece of information, let's assume the police knew that piece of information and deliberately omitted it from the search and seizure warrant. Does that omission diminish probable cause, or obviate it entirely? That's the question of Frank's hearing. Like, in other words, if we remove the evidence that was illegally obtained, or that the police allegedly misled the court about, would the court have found probable cause nevertheless? That's the question
Yeah, and that's a really
for
hard
this
one.
defendant and for these crimes. Because
Because
just
as we had talked about before this, because if they knew, like, I mean, I think the cops might be okay, or whoever, whether it was the cops or the prosecutor, might be okay if they didn't know that Richard Allen had an alibi somewhere between six. So maybe
Well, that's my point, is
yes,
that we know that they did interview Mr. Allen, but that they interviewed him as back at the early on, and they had his statements. So the question in my mind is whether he's alibied out. Like if Mr. Allen went home at 4 o'clock and he's alibied from 4 o'clock afterward on the 13th of February, this absolutely diminishes pride. The police knew that when they applied for the warrant, which they most likely did. Then I think there is a big issue here, or a potential issue.
Potential issue. So I guess so. Let's
But
go.
again, our burden is very, very high when we're looking at a search at suppressing a search and seizure warrant. I mean, it's very difficult.
Yeah.
That's
So
a
I mean, the
very high
bar, as you
standard.
said, because usually they give quite a lot of faith into the police officers as long as they're acting in good faith for most warrants, unless they know completely that they were lying, like they were
Well,
completely lying or
then there is a good faith exception in warrant execution. The Leon, USB Leon, the good faith exception is where the warrant states the wrong address, which oftentimes is not unusual, particularly in some neighborhoods where the houses don't have addresses and the streets don't even have names. So there is a good faith exception. And again, in the geofence warrants, we've seen we've seen this alleged good faith. Um, but again, that's in executing the warrant, not in applying for it. There is no, again, remember, the executing the warrant is where USB Leon applies. We have the good faith exception in executing the warrant. Wrong house. They kick in the wrong door because nobody knows the address. However, the, Frank's applies to the application for the warrant. So when the police are talking to the judge and swearing under oath, here are the facts that support probable cause. In other words, if the police say to the judge, if the police know that the address is my address, but they tell the judge it's your address when they apply for the warrant, and the police kick in your door and find incriminating evidence, then we have a Frank's problem. However, if the police tell the truth when they apply for the warrant and they give them my address and they kick in your door, they've kicked in the wrong door and then they get the good faith exception. Do you see what do
yes,
you
I do.
see?
Yeah.
Yeah, the difference
So
between Frank's and Leon good faith in execution. No, there's no such. The police don't get that same pass when if they're mislead the court
I guess there's a
in
couple
the
of ways.
warrant
Sorry, yeah.
application.
So there's a couple of ways that the cops could show it. I mean, they could show it. We haven't seen it yet. Is the affidavit for the warrant? They could have written on that warrant, the affidavit. They could have said that we know that the phone was off between 6 p.m. and 4 a.m., but we still want to search Richard Allen's house for these
Correct.
specific reasons. And if they told the judge that in the affidavit, I think that would clear them. Correct? Like if they give all the facts
Absolutely.
and
Absolutely. That's the problem. Exactly. If that information is in the affidavit or anything resembling it, then probably okay. But I don't think it is in the affidavit because we wouldn't, otherwise, the defense wouldn't be raising the issue if that information was in the affidavit.
okay.
That's why we have a Frank's motion.
Yeah. So the burden of proof in this is the defense has got to prove that the cops were not like they knew it and they were lying on purpose and admitting
Right,
that,
by
and
omission,
it
because
was
the best
material.
lies are omission, not affirmative. I mean, we very seldom see affirmative misrepresentations in the Frank situations. Typically, what we see are lies of omission, where the police, like I said, the police knew that it was my address, but they put your address because they didn't have probable cause for you, but they wanted to kick in your door because they suspected that you were selling drugs. They knew I was. They'd get a warrant on me any day of the week. But do you see my point?
Yes, they do. So then, if adhere, and then so I guess then the procedure. I'm not sure what Gall will do in this case because she could. I mean, she would have her responsibility would be able to search at that original affidavit and find that search and seizure affidavit and read it and see what they originally wrote in their
Right.
probable cause.
It's an in-camera, when we, again, the procedure for Frank's hearing, defense files the motion and has to make the showing that there are material falsehoods, either by omission or affirmative misrepresentation. If we can meet that standard, then the judge will conduct what's called an in-camera hearing. In-camera means that counsel and client, the defendant, all go to the judge's chambers and we adhere the police under oath in the judge's chambers. We're on the record, but because of the nature of the proceeding, again, because that proceeding could taint the trial, we have to do it in chambers. And typically, the record from the Franks hearing is going to be sealed until we're done with it.
Okay. So I mean, I guess so. Just going forward with that, I guess we don't know right now what's going to happen. I mean, Gold could just deny this motion again, like any other ones.
Right.
But is
She's
this
denied
one?
2 or 3
Yeah.
of them already. She can deny, the judge can deny Frank's motion without a hearing. Again, the question is that, it's an issue for review, for appellate review. Like, was
Okay.
the denial supported by, was it an abuse of discretion, really, is the standard.
Okay. You've seen some of the other ones. I mean, the first Frank's motion was like 3 encyclopedias long.
It was
Um.
139 pages, I think. Again, sometimes in defense, we use motions practice for a number of reasons to introduce we want to give the judge a sense of who our client is and what their issues are, obviously. But motions serve they often have other agendas than their stated agenda, like a suppression motion, a Frank's motion, the 139-page motion, especially because this particular case, all the records were sealed from the public for so long. And this motion could have been, especially given its length and the amount of information that it contains,
Yeah.
it could have been like a message to the public. Again, I didn't really see a whole lot of argument that sounded like a Frank's motion in the first one.
Okay. But so this one, I think the fourth one is finally
This one
probably
was
if they
pretty
had
good.
so much better. You still think it's poorly written? You had a hard time reading it.
I think it could be a little bit clearer, but again, the defense they're working with. But remember, what we're seeing out here in the public is not the entire document, because the defense, again, I assume that what we're reading is being the affidavit and the portions of the affidavit that the defense wants is challenging. That's omitted because of the seal, because the case is all of the records are under seal right now.
Okay. But I think it's more
So
succinct and it has a better issue. I think people are still reading the Odinist angle and not understanding that, and it'd probably be better if it didn't have that. But I think
well,
that's what really has upset people about this case is the Odinism ceremony issue in general, and he probably brought that on too soon. I think if he had just done this,
yeah.
if he had done this motion, the first part, like the first time through, I mean, it's always easier. Hindsight's 2020. I think he would have had a lot more push.
But he couldn't, because again, and this is very typical in a Franks, for where we see Franks. This is my own experience. This information was not disclosed to the defense until a couple of days ago. I mean, again, this came to the defense only when they filed a motion to compel discovery. And again, motions to compel discovery in criminal cases are not at all unusual, but there have been more than a few of them here, and this information is being available. It was reduced, I believe, in very early on, back in February of 2017. So the fact that it was not disclosed to the defense until now is remarkable. I mean, again, it raises my eyebrows about the prosecution. But
Okay, well,
unfortunately, it's not unusual. It's been my experience that, it's 11th hour motion to compel. I finally get the evidence that is absolutely game changing. Like, I think this could be maybe.
maybe. Well, I think we both have our
Yeah,
theory on
I
what
don't know.
happened, but we're I guess not really going into that now. I guess um so I'm trying to think where I kind of want to go with this now because I think we've
On the
discussed a lot of
Odinism
it.
piece, because there are 2 affidavits from the DOC officers that the religion is not Odinism, or the quote unquote Odinism, because in prison that is, I've forgotten the name of it, is something Astra. It is a religion, a legitimate religion, and it is practiced in prisons and jails. However, they said they are not. This isn't their religion is pagan heathenism or something like that, and they were wearing patches that identified them as believers in this religion to DOC. I believe the warden of the facility where Mr. Allen is currently housed, and a guard, a DOC officer, who had started working at that particular prison in 2022. The DOC officer wore his patch for about 6 months while Mr. Allen was housed there, and that's probably what raised the issue. But there's nothing in that officer's affidavit about Mr. Allen making a confession or anything of significance. So who knows?
Okay, well, I think the biggest, I mean, after this, we'll figure out where this goes. The biggest problem that Richard Allen's defense is going to be handling those confessions. I mean, he supposedly has confessed to 30 people. Unfortunately,
Confessed what? What did he confess
I
precisely?
understand that he's confessed to the murder, but that's the whole
See,
problem is we don't know exactly what he's confessed to. I don't think we've heard the transcripts or
mm,
haven't heard any transcripts or what their affidavits of all these officers are. I think people have said they're out there, but we've not. So I mean, I mean, what
again,
those are and what he said is going to be the biggest trouble for the defense.
sure. I mean, if again, a confession with Miranda warnings. I mean, if there was, again, if we have a Mirandized confession, that's pretty compelling evidence. But some throwaway statement to somebody, to a cellmate, to a jailhouse snitch, a cellmate who's looking to work off some time, that's not exactly,
Well,
that's not so compelling. And yeah, again, the problem that I have with this whole thing is, yeah, I mean, we have this again to the I don't to the positive information. Mr. Allen admits to having been in the area. Okay, well, but that by itself is certainly not a crime. Walking on a bridge is not a crime. And there's no fire. I mean, again, there's this cartridge that was allegedly found at the burial scene, but it's a staged burial, and the cartridge was not fired. So the question again, evidently, the type of gun the police seized, the Sig Sauer P26. I forgot the exact model, but it's one that has a inherent defect. Sig Sauer stopped manufacturing in 2010. Mr. Allen acquired his firearm in 2001. Um, the problem is that the, there's a word for it because I know very little about firearms. It's where the cartridge in a semi-automatic weapon uh, does not it backs up. It doesn't properly fire, and so the cartridge could an unused cartridge could fall out of the weapon. Now, again, where did it fall from? Or was it just thrown there? Was it planted there? Who knows? Right. And again, there are like dozens of, probably tens of thousands of people even Indiana alone, registered gun owners that would use that have firearms that use that same cartridge. So,
okay, well,
again, I mean, I get why they're looking for, they certainly had probable cause to look for firearms and cartridges, but again, it seems like kind of a pretty big, a lot of fish in that pond.
okay, yeah, okay. Well, I think for now, I think we could probably wrap up. I guess, I mean, my purpose was just trying to understand what Baldwin is trying to do. I mean, I guess getting back to it, you don't think Baldwin's completely nuts. I mean, he does have some
No,
purpose of trying to do
well,
something. It may
again,
not
because this
work.
it's very hard to, I mean, it's almost impossible to win a Frank's, to actually win a Frank's, to a Frank's hearing. Again, it's short of fabricated evidence is very difficult. Or if the police, and oftentimes, typically Frank's hearing involves a confidential informant who has very questionable bona fides, questionable credibility, and the confidential informant's information is wrapped into the police information. Because remember, anything is admissible to prove probable cause. Hearsay evidence is fine. So where we see the problems is typically in cases involving confidential informants who have disclosed information to the police that is highly questionable.
Okay.
Like,
But that, yeah, that's
like there was one case that one of the few cases I saw where the defense prevailed was where the police never bothered to. It was a rape case. There was no again and Frank's itself, no eyewitness identification. That's and omitting the fact that the police never asked them for an eyewitness identification from a search and seizure warrant is extremely troubling.
okay.
That's a big omission. That is again, the omission must be material to probable cause. Obviously, eyewitness identification is as material as it gets to offender probable cause.
Okay. Well, we'll see it. I mean, the thing is that we're heading into May tomorrow. The trials, I think, supposed to start on the 13th. So they have a quick turnaround time. Like, I mean, Goal has still got to rule on the contempt of court issue before that happens,
Yeah,
and also
that's kind
the
of it's
in
a
the Frank's
mess.
hearing. So, I mean, and Gold came out today, I think, or I'd heard that she wrote saying that you guys have asked for a speedy trial, you do it.
You're gonna get one. Well, and
You're gonna
also
get it.
I think I imagine that she will hold the contempt petition, the contempt sub curia until the criminal trial is over, because Mr. Allen's Sixth Amendment right to counsel is clearly at issue with a contempt proceeding.
Okay.
So I
Well, that's
think
all. Yeah.
I would imagine that she's going to hold it sub curia and do again, you know, because at this point it would, I think, again, his right to counsel is clearly an issue on the contempt.
Okay. Well, that's a whole different issue. So, well, I would
Yeah,
like to thank you again for taking the time
sure,
to talk to
sure,
me, and I'm gonna
sure,
go ahead and stop the meeting.
sure. Take care, Mike. I'll talk to you
Bye.
later. Bye.